day in my trademarks class, I was speaking with a 2L, and we were conversing about a lot of the words or common phrases that she was not aware of prior to enrolling in law school or beginning law school. And for me, I actually did a lot of searches on Reddit and a lot of forums. I was searching like crazy, so a lot of the lingo actually understood. But if you don't have time, or if you're coming straight from undergrad and you just need a break that summer before you start law school, there may just be a lot that you don't know. And I know that some schools provide their students with materials that explain a lot of that in like an orientation packet. But if your school doesn't, it's no fear. We're gonna talk about the most commonly used words that you will hear among law students in law school. So the first one is case brief, or briefing a case. A lot of the cases that you will read in your casebook are redacted, meaning that they're shortened. There is a lot of material that isn't there. But some of the cases that you will read will be 25, 30, maybe even 50 pages, especially if it is a Supreme Court case. So with the case brief, you are just making a brief of that particular case, actually making that particular case in your casebook that is currently redacted. You're making a smaller version of it, more condensed version of it, so that you are able to get the particular rule or principle that you need to apply from that particular concept that your professor is talking about. So the components of a case brief are your facts. These are the facts of the case. Then you will have your procedural history. You will see how the case or how the parties were able to get to the current court that is actually reviewing the case. Next, you will have your reasoning or your analysis. I call it analysis. Some people call it reasoning. And this is where you take the rule section from above, along with the reasoning of how the court applies the particular rule to the set of facts that you listed at the very beginning. And that's your analysis. And then the holding, that is what the court decided. Did they affirm the court below? Did they remand it back, meaning send it back to the court below? Or did they reverse it, where they said that the lower court was completely wrong? Or did they reverse half and then accept half, affirm half? So that's really what is involved in a case brief. You will brief, just normally known as briefing or case brief, however you want to call it. You will do this for every single case that you have. And the more you do it, the quicker you get. Now that I'm a 3L, I really don't brief as much. I mean, I do. The second one is a horn book or a supplement. And I have my supplement here. This is a particular supplement. This is a crunch time one. I know it's in reverse because I'm just showing it to you really quick. There are E&Es, tons of supplements. A horn book, but think about like a rhinoceros horn, and then book or a supplement. Sometimes they're called treatise. These are materials that help you understand the law better. When you're in class, you really just need to focus on the principle, just this very narrow focus. But what about the whole world or the picture of where the law is that you're studying, or how it got to where it is currently? That's why you would need a horn book, a supplement, or a treatise. All mean the same thing. Go to your law school library, check them out there, and they expound on it. They give you some history of why this happens, or why this particular law is in place, or the changes that have gone through it. I know for me personally, when it's closer to finals, I actually will download the horn books because my school has them online too, and just read them because it gives me a bigger picture of what I've been studying the whole entire semester. The next one would be E&E, and these are examples and explanations. So I'm going to show you real quick. I have a copy of one here. This is the one for civil procedure. I know it's reversed because I have my camera going the other way, but E&E, that's just what they're called. These are similar. This would be called a supplement. But if you hear people on campus saying E&E, it just means examples and explanations. It is a type of supplement that you're able to use, a type of supplement for law school. Cold call. Cold call is basically the Socratic method. If you're not familiar with that style of method, where the professor will cold call, which means they just called a random person and they will ask you questions about the case. Not only about the case, but they will give you hypotheticals. The professor will call on one student and they will go over the case, and it's called the Socratic method, where you're just asking a bunch of questions to be able to get to the reasoning, the holding, and the professor will give you hypotheticals, which is another word we'll go over next, where they will change the facts a little bit and then you just answer the questions. So a lot of people get nervous with cold calls. I mentioned before, I do get nervous, especially if I haven't read. Even if I have read, I still get nervous because Those questions are intense or a little difficult. I know for me, as I mentioned earlier, I do get nervous when I am cold called because the questions are really in depth for me. Not going to lie, I don't do well with cold calls, but it really doesn't matter because cold calls are not on the final. So, I mean, I do my best to answer. And if you don't know, then you just don't know. You do not want to say that you haven't read. So try your best to read. But if you honestly don't know what the professor is asking, you can ask them to repeat themselves or just say you don't know because they've been over those cases a lot. So they know those cases like the back of their hands. So they're able to come up with questions that will make you think differently. So that's the purpose of a cold call. Next will be hypos or hypotheticals. This is what I did not know, and I don't do hypotheticals well. Hypotheticals are where you take the facts of a particular case that you're studying or that you're going over with your friends in your study group. And what you will do is you will switch up the facts a little bit. Let's just say that A and B were driving the car at 50 miles an hour and there was a crash. So a hypothetical would be, what if A was driving and B was riding in the car going at 50 miles an hour and B hit A, or A hit a spot and the car slid, crashed into a tree? It's unfortunate. Hypothetical would be A is driving and B is riding in a car. A is going at 95 miles an hour. The roads are wet. A slides and crashes into a tree. B is suing A. Or you could switch it up and say A is driving, B is in labor having a baby, and same incident happens. Or A is driving and B is riding and they're going through a school zone and they're going at 50 miles an hour when the speed limit is 35. Hypotheticals just change the facts a little bit and you would see how you would apply the law differently based on a different set of facts. Those are hypotheticals. The next one is Blue Book. Blue Book is just how you do your citations. You mostly deal with Blue Book in your legal writing classes or your advanced legal writing classes. Here's my copy of my Blue Book for my 1L year. They update the book every year and it's pretty much just how we do our citations. For law school, some employers may still expect you to Blue Book. I know I did an externship with the judge and she wanted me to do citations according to Blue Book. And then over my summer employment, they just wanted just the documents. However, they wanted them, like the citations really didn't matter. So the next one is memo. A memo or memorandum is your work product, which is what you turn in to your employer or your judge or whomever. It's just the work that you did and it's called work product. And normally it's just a memo where that is internal. So that goes to your partners, that will go to the founder, that will go to a higher level attorney. That would not necessarily go to the client. In a sense, the memo is how your email communications between other attorneys or between yourselves or between your boss. And you also have to write a memo. I know we did in 1L, and so there are just certain rules and formats for writing a memo. That's a memo. So the L's, a lot of people are wondering, 3L is the third year law student, which I am a 3L. A 2L is a second year law student. A 1L is a first year law student. And an O or a 0L is a person who has not started law school yet. They may be thinking about law school or they may have applied and are accepted and just have not started yet. Those are the L's. Another one is PI. So PI stands for a lot of things. It can stand for public interest, which is the type of law that you would practice or you would work in that particular sector. You would see a lot of, I forgot the name. I can't think of it. But like if you're working for the government, if you're a public defender, that's what I was thinking of. Or if you're working for some sort of like association, nonprofit, all of that will fall under public interest. PI can also stand for personal injury, which will fall under the torts set of laws. It's a type of tort. Personal injury, that's like that type of thing. I actually did personal injury work over the summer and I can talk about that. And then it also stands for private investigators. So a lot of criminal defense attorneys, or actually also prosecutors too, work with private investigators. So if you're wondering what PI stands for, it could be one of those three things. Just pay attention to the context. Next would be principle rule. I struggle with this like crazy because I was like, what is a rule? What is a principle? So back to your case. With your case, you will just have this one little point or this piece of information that you need for your class. And that right there is the particular rule of law.
Part 2 is coming next week. Stay tuned.